So welcome everybody. We are so excited to have you in class today. Today's topic is constitutional battles of, but we're really going to be looking at this idea of separation of powers. So my name is Kerry Sautner. I'll be your moderator today, and I am here with our top scholar, Jeffrey Rosen, who's going to walk us through this constitutional history, even like pre-constitutional history, all the way to modern cases. So our goal today is to go from Montesquieu to subpoenas. Let's see if we can do it all in 30 minutes. Jeff, are you ready?
I am ready. Hi, Kerry.
Hi, how are you? Happy Monday.
Happy Monday.
Okay, Jeff, so we have, go ahead.
Go ahead.
So we have a lot to go over today. So I kind of broke it down into 4 sections. The first section being like defining these ideas. So this idea of separation of power, this idea of checks and balances, just like federalism, it's all over the Constitution. So let's make sure we understand what it is, why we have it, and what was the intention behind it. And then we'll really get into the founding story, maybe touch upon Marbury versus Madison, which I keep calling Mayberry because I think I'm in just a Mayberry mode today. And then Nick was like, I think you mean Marbury, Jackson's veto, and then modern battles. So there's a lot of good questions around this. But my question always starts really simply with, so we have this system of separation of powers and checks and balances that sometimes can create battles between the branches. Was this intended by the founding fathers? Was that their idea to create the system so there would be a little bit of a struggle, tug of war in it?
Yes, it was. And we know that from the very first words of the Constitution, we the people, that central idea, which came from James Wilson, that in the US, we the people have the sovereign or ultimate power, not we the parliament, as in Britain, not we the king in parliament, as in Britain and other European countries, but the people. And because we have the sovereign power, we parcel out portions of it to some different aspects of government, but no single branch can speak in our name. Our will is embodied in the Constitution itself. And then to be extra careful to make sure that none of the branches abuses its power and becomes too strong and claims to speak for us, then we have checks and balances, which blend the various aspects of the branches to ensure that they can keep an eye on each other. So for checks and balances, that's the mixing of powers. It comes from mixed government theory from the Enlightenment, and it goes back to the Romans and Greeks. Aristotle had a powerful idea of the pure forms of government, namely democracy, the people, aristocracy, the Senate, and monarchy, the king, each of which could degenerate into its illegitimate form. A democracy could degenerate into oligarchy or the mob. Aristocracy could degenerate into oligarchy or rule by the few, and monarchy could degenerate into tyranny. So the way to prevent that, according to mixed government theory, was to blend the various powers to ensure that they could check each other. And the most obvious examples of checks and balances in the US are Congress passes laws, the president holds the veto power. Congress can override the veto with a 2/3 majority in each house. Or the president can nominate Supreme Court justices, as we saw just today with Justice Amy Coney Barrett's imminent confirmation, but the Senate gets to decide whether or not to confirm them. And the same thing for treaties. The House initiates impeachment proceedings, but the Senate alone conducts the trial. So the framers are combining this mixed government theory embodied in checks and balances with separation of powers expressed in the fact that Article 1 vests all legislative power in Congress. Article 2 vests the executive power of the government in the president, and Article 3 vests the judicial power in the Supreme Court. So that's the big idea. And I can't resist, but why don't we check out the interactive Constitution to see some of James Madison's early drafts for amendments that would have made the separation of powers crystal clear. So I always get all excited about screen sharing, and then I conk out. So let's see if I can do it. Here we go. let's just give it a shot here. And you know what else we should do? I'd love to read together from Federalist 51. But so here we go. And here's the Great Interactive Constitution. And then if we get to it from, say, I'm looking for the drafting table, friends, which is the wonderful tool that allows you to see early drafts of every provision of the Constitution. And if we do the drafting table for the First Amendment, then we're going to get to this incredible tool, which you can also find. It's called Constitutional Rights at the NCC. So here are all the early drafts of the various amendments. And here are the provisions that were not adopted. And look at Madison's 18th proposal. The powers delegated by this Constitution are appropriated to the departments to which they are respectively distributed, so that the legislative department shall never exercise the powers vested in the executive or judicial, nor the executive exercise the powers vested in the legislative or judicial, nor the judicial exercise the powers vested in the legislative or executive departments. So that was not adopted. That would have been separation of powers on steroids. It would have made crystal clear no branch can exercise the powers of the other. The framers were not ready to go that far because they wanted to have some blending, a vestige of that mixed government theory from Montesquieu and Aristotle, and therefore this wasn't adopted. Not long ago, Senator Rand Paul, who is a libertarian senator, came to the National Constitution Center and saw this provision, and he said, imagine how much mischief would have been avoided if this provision had been adopted, because more libertarian-minded people today, libertarian means putting liberty first, really don't want any of the branches to exercise each other's powers because they want to limit power in a very dramatic way. And Senator Paul would have been a fan of this 18th Amendment. All right, Kerry, what do you think?
Yeah, I was going to say, do we want to take another beat on how well read the framers or the founding fathers were? Because I love this idea that, you know, they come to the Constitutional Convention. Madison does his homework, because Madison always did his homework, but he's reading people like Montesquieu, like Locke, and pulling ideas from them, but then making something new. When they begin to make something new, there's pros and cons of each. So when you get into Federalists and Anti-Federalists, what are some of the worries that the Anti-Federalists have for it? And what are some of the pros that the Federalists say about this concept of separating powers, giving everybody a job, but then making them work together in a way that I like to think of as healthy competition and healthy engagement with each of the branches in the best case scenario?
Well, the framers were incredibly well-read, and I have just been reading a really interesting book on how the classics influenced the framers. It's by an author called Tom Rice. It's about to come out, and we're going to have a great program on it at the Constitution Center in the beginning of December. And there's another wonderful book by a scholar called Carol Winterer about how women in the founding era, they tend to be more elite women, were also incredibly well read in the classics, and they read Aristotle and Montesquieu and A History of Ancient Greece and Rome by a guy called Charles Rollins. Friends, if you want to really channel what the framers themselves read, then here's some reading recommendations. Charles Rollins, Ancient History of Greece and Rome, and then the translations of Homer's Iliad and Odyssey by Alexander Pope. He was a great Enlightenment poet and philosopher. He writes in beautiful blank verse. He's the one who famously said, "The proper study of mankind is man." And his translations of the Iliad and the Odyssey are very beautiful and were read by everyone. So yes, they were incredibly well read. But why don't we get a sense of how well read they were by reading together from the Federalists, because Madison gives such a good sense of what he has in mind there. And it's the Yale Avalon project has all the Federalist Papers online. Here we go. We're going to see how my screen share works. Okay, Federalist 51. Of course, we can't read it all, but it's good to read it together because he's talking about how do you maintain the necessary partition of power among the several departments as laid down in the Constitution. He says you have to contrive the interior structure of government so its several constituent parts may, by their mutual relations, be the means of keeping each other in their proper place. So it's got to always be rested in a dependence on the people, but then you need auxiliary precautions, because although it's important that the people be virtuous, that is, they tame their passion with reason, that's how the framers defined virtue, you need extra precautions like checks and balances and separation of powers, the policy of supplying by opposite and rival interests. The defect of better motives might be traced through the whole system of human affairs, public as well as private. He was very keen on a veto, especially of Congress on the states. And he said an absolute negative on the legislature appears to be a natural defense, which the president should have, but maybe it wouldn't be safe or adequate. And he runs through the various possibilities of that. But then he talks about civil rights. But the part that I really want to find, and maybe one of you guys can see it before I do. Here we go. Ambition. This is the famous paragraph. He says the provision for defense must, in this as in all other cases, be made commensurate to the danger of the attack. Commensurate means appropriate or proportional to the danger of the attack. Here's the famous words. Ambition must be made to counteract ambition. The interest of the man must be connected with the constitutional rights of the place. Wow, this is an amazing sentence or paragraph. It may be a reflection on human nature that such devices should be necessary to control the abuses of government. But what is government itself but the greatest reflection of all reflections on human nature? Listen to this, friends. If men were angels, no government would be necessary. If angels were to govern men, then neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the government. You must first enable the government to control the governed, and in the next place, oblige it to control itself. Ah, that is so great. Isn't it amazing? So ambition counteracts ambition. The president's going to be ambitious. He's going to want to expand his power. Congress is going to be an impetuous vortex that's going to suck all into its voracious maw, according to Madison. These are the words he used. The way to cure that is to pit the branches against each other so they can fight. Neither can gain preeminence. And in this way, the sovereignty of the people will be preserved.
And so what I love about that is explains the title of the class, Battles of the Branches. So Madison and others are very worried about ambition, greed, but also trying to utilize, in a way, jealousy to make everybody check each other and control each other in a way that works best for we the people. So what's our biggest kind of first test on this? I'd love to jump into some of the big court cases like Marbury versus Madison, and maybe the Jackson veto to see kind of how did this, so they put this theory into the Constitution, they spell it out in the vesting clause of Article 1, 2, and 3, and then the Constitution is given back to we the people for ratification, it's ratified, and it goes into play. You know, the play is in call, and Marbury versus Madison is one of the first tests. So can you jump us through that court case and then the bank wars and Jackson?
Sure.
Well, I actually love talking about Jackson, even though sometimes he's not the most lovable of all of the presidents.
He's not the most lovable, but he was a very important president, and he was the first president who claimed to speak in the name of we the people, the first populist president, which is one reason our current president, who considers himself a populist, has a portrait of Andrew Jackson in the Oval Office. Marbury, let's just do one takeaway from Marbury, because the facts are complicated and it's not the central test of separation of powers. The big thing Marbury did was establish the power of judicial review, namely the power of the courts to strike down unconstitutional laws. And you can get the whole idea of Marbury from Federalist 78, where Alexander Hamilton explains what happens when a judge confronts a conflict between the will of the people represented in the Constitution and the will of the legislators represented in ordinary laws. And Madison said, when confronted with such a conflict, it is emphatically the duty of the judiciary to prefer the will of the master to the servant, the principal to the agent. So in other words, we, the people, are the principals, our legislatures are our agents, and by favoring our will as embodied in the Constitution rather than those of our legislators represented in laws, then the courts are not thwarting popular sovereignty, but perfecting it. Now, that's a, kind of important, maybe counterintuitive claim. Is it really the case that when an unelected judge strikes down a law passed by Congress today, say the Supreme Court were to strike down the Affordable Care Act, which it's going to be asked to do, and we'll hear that case in November, can we really say that it's privileging the will of the people over the will of the legislators? We might say, what are you talking about, judges? You're substituting your will, your unelected will, for that of the people's representative in Congress. So much of the theory turns on the idea that you really believe that judges are neutrally interpreting the Constitution and that the will of the people is embodied more precisely in the Constitution than it is in ordinary laws. But that's the basic idea of Madison, and it certainly was Marbury and Madison, hugely important for establishing the judiciary as a fully co-equal branch of government, able to exercise its power to check the president and Congress. Significantly, the court used that power very sparingly, and in the first part of the 19th century, it struck down federal laws only twice, in Marbury itself in 1803, and then again the second time was in Dred Scott in 1957. No federal law struck down between 1803 and 1857. By contrast, between 1995 and 2006, there was something like 26 federal laws struck down, a whole lot more. The court is much more active today than it was then. So that's Marbury. What do you think, Kerry? Should we talk about the bank case?
I think the bank case is a good founding for our students. And then I'd love to jump to, let's see this play out in modern cases, because our students want to hear like what's happening right now around this concept of separation of powers as well.
Absolutely. So there's old Andrew Jackson looking very
intimidating.
Intimidating. He's got some very important hair. No question about that. Very impressive. And our quotation here says the national bank is unauthorized by the Constitution, subversive of the rights of the states, and dangerous to the liberties of the people. What's so significant about that is that the Supreme Court under Chief Justice Marshall had reached the opposite conclusion. So what happened? Jefferson and Jackson thought the Bank of the United States is unconstitutional. Jackson was pressed to veto a bill that Congress passed in 1832 to extend the charter of the Second National Bank. And then he issued a veto message in 1832, and his essential message was twofold. First, that the bank is unconstitutional because there's no power given in Article 1 to charter banks. And second, that the president represents the people and the bank is against their interests, and therefore the president representing the people has to destroy this threat to the liberties of the people and to the states. And his conception of federal power turns on his understanding of the clause of the Constitution, the necessary and proper clause. He thinks that the bank is convenient, but not necessary. It's unauthorized by the Constitution, subversive of the rights of the states, and dangerous to the liberties of the people. And then he says that I think, some people say that the Supreme Court should decide this. I don't agree. Mere precedent is a dangerous source of authority and shouldn't be regarded as deciding the questions of constitutional power, except where the acquiescence of the people and the states can be considered as well settled. So he says that it's not the Supreme Court alone that can decide, but people have to accept the court's decision. And then Jackson moves on to criticize the court's decision in McCulloch versus Maryland, which the court had decided quite recently in 1819. So it was not too long after the bank was chartered. And in McCulloch and Maryland, the court said that the necessary and proper clause could include anything that was essential or needful, and as well as being convenient. And he interpreted the clause broadly and said it's the power of the judiciary to decide what the law is, and as long as the end be appropriate and the means are adapted to the end, then the law should be upheld. And Jackson disagrees. He says that this seems to suggest that it's the exclusive power of Congress and the president to decide whether the particular features of the act are necessary and proper. This would result in unlimited federal power. And therefore, Jackson significantly outlines this theory that Congress, the executive, and the court must each for itself be guided by its own opinion of the Constitution. In other words, the judges aren't the only people who are allowed to interpret the Constitution. Back to Jackson, each public officer who takes an oath to support the Constitution swears he will support it as he understands it, not as it is understood by others. The authority of the court must not, therefore, be permitted to control the Congress or executive when acting in their legislative capacities. So this theory of departmentalism, that each branch gets to evaluate constitutionality on its own, basically says all three branches have to agree on the constitutionality of an act or law before it can go into effect. Jackson isn't denying Marshall and the court's ability to say what it thinks the necessary and proper clause means, but if he disagrees, he's going to use his veto power to enforce his constitutional vision, and that's why he vetoed the bill, because he believed it was constitutional, even though the Supreme Court had disagreed. It's a very interesting theory, isn't it, friends? And it kind of puts a big premium on the president and Congress to evaluate laws in constitutional terms, just what Kerry and I are asking you to do, not to just leave it up to the courts to say what the Constitution means. But when Congress passes a law, it should make a judgment about what the Constitution requires or forbids, and same for the president. And all three branches have to agree before it goes into effect. So that is the basic idea of McCulloch.
Yeah, and I think this case is so important because when we look at a modern case, we're going to be asking that question first. Is that branch doing that job in the constitutional duties that they have? Begin there. Is that their duty? Can they do that? And then are they applying it in the right way? So that's what I love about it, one of the current ones. But before we get there, Colin does have a really good question, and I think it fits around Jackson perfectly. And he says, wouldn't you say that presidents over time have taken the power that aren't granted and Congress hasn't used it? So have we seen that over time where presidents are pushing those powers and maybe not being given those explicit powers?
Absolutely, Colin, that is a very powerful point, and I think you're absolutely right. And then you'll go on to say Congress itself has ceded its own power to the executive in a way that's inconsistent with the Constitution. Well, whether it's inconsistent with the Constitution depends on your vision of the Constitution, of course, and people can disagree about that. But it was certainly inconsistent with the original understanding of the framers. They thought that Congress would pass the laws and the president would enforce them and the judiciary would interpret them. Starting in, we talked last week, I think, about executive orders. And we saw that there was a huge spike in the number of executive orders issued by the president, first during the Civil War under Lincoln, and then it went up hugely again in the Progressive Era under Theodore Roosevelt and Woodrow Wilson. And then during the New Deal in the 1930s, it spiked from, like 1,000 to 3,000. It just went up a whole lot. And now it's, in the high two figures. That's not what the framers intended. They expected that Congress would be the impetuous vortex and the president would just be carrying out Congress's will. Now, as Colin suggests correctly, we almost have 2.5 branches of government where the president does most of the lawmaking through executive order. Congress can rarely rouse itself to act except when it comes to confirming judges, which we saw they're very active in doing recently, or occasionally passing a budget. And then the court has become much, much more active than the framers expected in trying to strike down laws. And that has thrown off the balance just in the way that Colin suggests.
Okay, so again, that separation of powers, checks and balances is like, it's supposed to work as a perfectly balanced three-way teeter-totter. So you don't have a skew in one direction or the other. Now, fast forward, maybe I can't do the math today, but like almost 200 years later or 201 years later to this case. We have 5 minutes left. I love to end with a current case. Here's the big question around it. How much power does Congress have to investigate the president's private finances and history? And that's why I like to jump from that case with Jackson to this. because the question first begins with, is it a part of Congress's duty to do this? Yes or no, what gives it the power to look at the president, and what is in the president's rights and privileges to be reviewed with a subpoena by Congress or not. So it really starts to unpack everybody's duty as well as everybody's ability to check each branch. So walk us through this case, Jeff, kind of dive into it and unpack it, because there's a lot in here, but it's a fascinating separation of powers case.
Yeah, the subpoena cases were really fascinating, and it would be so wonderful, friends, if you would read them. Just go online and Trump versus Mazur, and you can find them, and they're really fascinating. You can also hear the National Constitution Center's recap of the oral arguments, which we did with C-SPAN and which are on our podcast. But here's basically what was going on. Trump versus Mazur, the question was how much power Congress has to investigate the president's private finances. Congress's power to investigate usually comes through the use of the subpoena power. And the question is, when can you issue a legislative subpoena from the House of Representatives for information about the president? And the president said these were a violation of the separation of powers because there was no legislative purpose behind them. In other words, Congress, he said, wasn't using it because it was needed to collect information in order to pass laws. It just wanted to go on a fishing expedition to find out dirt about him so that they could embarrass him and perhaps lead to his prosecution. So the Supreme Court, in a majority opinion by Chief Justice Roberts, 7-2 opinion, so he got a lot of justices to join him, held that the lower courts didn't take adequate account of the significance of the separation of power concerns. Usually disputes between the branches were resolved amicably and not by the Supreme Court. Under earlier case law, the legislative branches do have the power to get needed information, which is necessary for legislation, but the subpoena has to be related to and in furtherance of a legitimate task of Congress and serve a valid legislative purpose. So that, and he cited a case from the 1920s called the McCain and Doherty case, which talked about the need for a legislative purpose. Then he looked at the Nixon case, US v. Nixon, which required Congress to show a demonstrated specific need that the subpoenas were demonstrably critical to a legislative purpose. But those involved executive privilege, so he wasn't going to take that rigorous a standard and say it was critical to a legislative purpose. That would really restrict the power. But at the same time, there's not unlimited power to get whatever records you want, because that would allow Congress to aggrandize itself at the president's expense. These separation of powers concerns, said Chief Justice Roberts, are unmistakably implicated by the subpoenas here, which represent not a run-of-the-mill legislative effort, but rather a clash between rival branches of government over records of intense political interest for all involved. So the court came up with a multi-part test. It said the court should carefully assess the legislative purpose given for the presidential records. Second, it should insist on a subpoena no broader than reasonably necessary to support the legislative objective. Third, Congress should treat more detailed and attentive evidence of a valid legislative purpose as better. And fourth, it should assess the burdens placed on the president by the subpoenas as part of interbranch rivalries. That's a lot of words. A lot of lawyers call that a multi-part balancing test. But basically it's saying, hey, judges, look at these subpoenas and balance the president's needs against Congress's needs. Don't assume Congress can get everything it wants, and don't assume the president can withhold everything he wants. And that was the Trump and Mazur's case. Completely fascinating.
And that brings up Nick's great question. Does political polarization throw off this balance of power? Madison's notion that ambition must be made to counteract ambition. Can it go too far? Too much ambition? Too much rivalry?
Can Congress go too far?
Any of the branches. So the question is, can this polarization throw off how the system works?
Well, absolutely. Any branch can go too far. We know that from the cases we've already discussed. The president can go too far, as we learned in the Youngstown versus Sheet and Tube case, when President Truman tried to seize the steel mills using his commander-in-chief power, and the Supreme Court said he was exceeding power that Congress had delegated, and his commander-in-chief power didn't include the power to seize the steel mills during the Korean War. Congress can go too far, according to the Supreme Court. when it passes laws that exceed its powers to regulate interstate commerce. That happened during the New Deal when the Supreme Court struck down part of the regulatory state. And 4 justices said that that had happened in the Affordable Care Act case. And in fact, 5, Chief Justice Roberts joined the conservatives in saying Congress had exceeded its commerce power, although he upheld the law as a valid tax. And then the courts themselves can arguably go too far. We know that when Congress reverses a statutory interpretation of the court, as it did in the Lilly Ledbetter case, Congress is signaling its disagreement with the court's interpretation. Or you can just have strong criticism of the court's decisions in constitutional cases, which can't be overturned by Congress. They'd have to be overturned by a constitutional amendment. But critics of the court's decision in Citizens United or in Roe v. Wade say that the court went too far in those cases, and that's why they want those cases to be reversed.
And that is exactly what Colin was asking. Can the courts go too far? And you just explained that perfectly. So it's a delicate system. It is a really expansive and thought out system, but it is a delicate system, and we're watching the interplay between all of it. What do you think is the big takeaway from this, Jeff, that our students should really hold on to when they're looking at these cases pop up and these battles between the branches? Is there, some steps that they should do to say, is this within their power? Is this too far? Is the system working?
Well, the question, can they do that, is a great question. So it turns out that so much of our protections for liberty and equality come not from the Bill of Rights, but from these structural limitations on the powers of the various branches. So we've just learned from this conversation today that the branches do have limited powers. They're enforced in different ways, sometimes politically, sometimes judicially. So anytime you hear a claim that one of the branches is exceeding its powers, dig in for yourself. Read the arguments in favor, read the arguments against, read any judicial precedents, start with the text. Always read the interactive Constitution, which has so much to say about each of these powers, and make up your own mind. It is so exciting in these very troubled times, friends, that the American system, unrivaled in the world, today in France, the president has far more power than the American president, or in Britain, Parliament has far more power. In the US, each branch has significant powers if they choose to exercise them. And that's why it's also so important that each branch does its job and exercises the powers that Congress granted it and the Constitution did.
I love that. My favorite constitutional question is, can they do that? I perpetually ask it. So always start with, can they do that? And then do a constitution check and use your interactive constitution. I love that kind of setup, and empowering all of our students, no matter what age, no matter what grade, no matter where you are in the country, to be able to check your own constitution and ask those questions. So thank you so much, Jeff. That was a great class, kind of understanding the system and the history of separation of powers, and then watching it play out every day in our fascinating government system. So thank you so much, Jeff. Thank you, everybody. Have a great day, everyone.
Thanks, everyone. Thanks, Kerry. See you soon. Bye.
See you. Bye-bye. Thank you, everyone.